Hey guys, welcome to our first Legal Nerd Show. We are live here. I'm Jen Taub and my co-host is Daniel Uhlfelder. A couple things about the show. This is our first time doing this, so be patient with us. And we even hardly know each other, so we're going to get to know each other as you get to know us as a team. A bit about me. I am a law professor at Wayne State University in Detroit, and my background before that was in corporate law, most recently in financial services, working for Fidelity Investments. You, Daniel?
Yes, I'm really excited. This is going to be a great adventure. I'm a lawyer down here in Florida. I've been practicing 28 years. I do pretty general practice, real estate, family law, go to court a lot. But I also clerked for a federal judge after law school. And so I'm just excited to be here and, try to go through the, things that exciting and new decisions that are coming out.
And we're going to bring different perspectives. I'm a Yankee. He's a good Southern boy. And, both of us know how to break stuff down into the important pieces. I can do it a little bit like a law professor in this weird kind of theoretical context, as well as, down to earth. And Daniel is literally practicing every day and knows how to break stuff down to keep his clients out of jail. So what's the breaking news today, Daniel?
Well, yes, it's kind of the Supreme Court, I guess it's a surprise again. We've got a couple opinions that were planned to come out this morning and on a regularly scheduled. And then just recently it was broke that an opinion that was put on the website, the Supreme Court website, that Bloomberg News apparently got access to while it was briefly on there. And then it was removed. And now apparently it was a 6-3 decision, and a very important decision regarding a challenge to Idaho's abortion law.
Oh my God. So you're talking about the big EMTALA case? What did the Supreme Court decide? I'm new to this. Wait, what's going on?
Well, basically, after the Dobbs decision, of course, there's been numerous cases brought all over this country. There's been several states here in Florida has enacted new laws, Idaho, all over the country. And I guess Idaho enacted a law that the Biden administration felt was in violation of federal law. So they filed suit to get to challenge it, and I think there was a stay issued, so that there was not a stay issued at district court to prevent its enforcement.
Wait a second. I'm just refreshing my memory now. So Idaho, after the Dobbs decision, are they the one who passed that law criminalizing most abortion procedures, even like not making an exception for emergencies? And that was the one that was in contrast with federal law?
Yeah. Not unexpectedly, Idaho is, fairly conservative, if not one of the most conservative states. And yes, they took a lead in making really restrictive and punitive measures in pursuit of Dobbs. And I think, from what I understand, this was maybe the first challenge from the Biden administration under this EMTALA to any of the states. So it definitely has a lot of precedential value and importance, because Dobbs, when it, first of all, the way it came out was very unusual, but now the ramifications are we don't know. I mean, there's so many unquestioned questions and uncertainties. And I think that, in order to preserve the right to have safe and, have this choice, that the Biden administration challenged the Idaho law that they felt was extreme. The district court, I believe, issued a stay of the law that went up to the Ninth Circuit. And then in this opinion, I guess, I don't know if we call it an opinion.
I'm sorry, go ahead. I don't want to cut you off.
So this opinion, again, I don't know if we can call it an opinion because it's not published, appears to have dismissed the challenge. So the stay appears to be, appears to be no stay, if that's my understanding.
So let me just see, because I'm catching up as you're explaining this, and I found this. There's this great website called oyez.org, OYEZ, like what they say, oyez, oyez, in the court, right? And so what I'm catching up on is the Biden administration had helped enact this federal law, or this federal law already existed, and we're calling it EMTALA. That's the acronym. It's the Emergency Medical Treatment and Labor Act. And that federal law requires any hospital that gets federal Medicaid funding, that's the funding link, to require what's called necessary stabilizing treatment if you're having a medical emergency. So that could be you're having a miscarriage, or there's something wrong with the fetus and the pregnancy isn't going to survive, and so on. But Idaho saw the door open with Dobbs in 2022 and said, you know what, we're going to pass a really restrictive abortion law. So then there's like this challenge from the Biden administration. I think there's another case that came up. And so I want to kind of break down the procedural stuff you said is stay. So when the Biden administration sued to stop this law, the court, I guess, the trial court said, okay, we're going to temporarily, preliminarily put it on hold. That's what a stay is while this litigation goes forward. Then I guess Idaho appealed that because they want the stay lifted so they can start having this terrible law. So let's cut to the chase because we haven't even said, did the Supreme Court side with Biden or Idaho today?
Well, I think it appears that they would have sided with Idaho, in my interpretation. Because
Well, they what did the Supreme Court do today? Did they?
well, we don't. What they do, we're not sure.
Okay,
Again, we're
so
all
if
contingent upon this opinion, basically that the court voted 6-3 to lift the stay.
no, they lift the stay or to dismiss the case? I thought.
They dismissed the case. That's
Right.
what my reading is.
Oh, so if they dismissed the case, then they didn't lift the stay, right? So
Right.
what does that mean?
Well,
They dismissed the
let's
case.
talk about what a stay is for folks. A stay is basically, when as a case goes through the court system, there's a trial court, whether it's state or federal, then there's appellate court. And when a case is going through that process, oftentimes one or other side will seek to have a stay of that decision, so it can go through the full process. I guess in this case, the district court made a decision which I believe was favorable to the Biden administration.
Yes. So the district court said, we're putting a stay, we're borrowing this law from going in place, right?
Right, and then there's another stay. So there was a stay, the law, and then apparently the Ninth Circuit, there was a request for the Ninth Circuit, I believe, to stay the trial court decision, and that and they denied. They said they.
I see. So the trial court said, we don't want this Idaho law going in place while you litigate. It's just going to be frozen. And then the Ninth Circuit said, yeah, we'll stick with that. We're not gonna interfere with that. So basically, the case came up to the U.S. Supreme Court, where the Idaho people really want this law to go into place. So today, the Supreme Court did something really weird. I mean, one, it leaked, but two, if this is the actual decision, they decided to just dismiss the case.
Right,
that's weird, right?
I don't believe there was any adjudication on the merits, so it's kind of unclear what their position is on this law. So at this point, if they dismiss the case, then I guess it would go back to the district court the opinion would, I imagine, be the only enforceable court order. And that's
right. And now the case moves forward then, right? Because they're still litigating on the merits then.
Right. So basically, I guess the question is, does the law that's in place by Idaho go forward?
No, because I don't think so, because this is what's confusing. The case started, there was a lawsuit from the Biden administration saying, we don't like this Idaho law. And while we're challenging it as being in violation of EMTALA, while we're challenging this law as being against federal law, we want you to put a stay, Judge, on the Idaho law going into place. And the judge said, sure. So now where we are, because the Supreme Court dismissed these appeals, right now the status quo is that the Idaho law is the Idaho law is frozen. It's not going to be active. So on the one hand, people are saying this is really good. But actually, it's not so good, right?
Well, I guess it's all breaking like just within minutes, and it's also it's a leaked decision. So just like the Dobbs decision that came out early, we're basing this on a decision that's not even final, but which is very extraordinary. But yes, if based on what we can read from this, it looks like that I guess they will have a trial court will have to have a trial on the merits of the case, and then I guess presumably, depending on what they rule, then it will go up the chain again. But I guess, I think is it good for the Biden administration? Is it good? I mean, I guess it's kind of in the middle because it's just, which I think is a lot of happening with these abortion decisions and the laws, or is that there's it's very uncertain what is allowed, what isn't, what the states, you heard the other day, I guess, candidate Trump is saying, well, we want the states to decide. Well,
Right.
what does that mean? I mean, like here
You're
in
so
Florida,
right.
we have a
Yes.
6-week abortion ban here in Florida. And there's certain exceptions. Some states have, like in this case, they were criminalizing. I guess they argued that the state law, which criminalizes providing an abortion, except in a few narrow circumstances, including to save the life of the mother, is preempted by federal law. I doubt that the Supreme Court anticipated, maybe they did, that there would be federal. I don't see why there wouldn't be. That because we've had Roe v. Wade for so long, there's been obviously a lot of federal laws and statutes and regulations that have kind of followed that precedent.
Right.
So when you just dismantle it, like I think the Biden administration pointed out, well, you're dismantling one thing, but there's all these other you haven't addressed. It's just basically
this is exactly
threw everything to chaos. I mean,
yes.
And now this is one of the effects of the chaos playing out in real time. And I think the Supreme Court, I can't speak for them, but maybe they just punted. Basically, they kind of punted on it, I would say.
Well, I think you're exactly right. You sound, Daniel, a lot like Ketanji Brown Jackson. And I only know this because it looks like Mark Joseph Stern from Slate, who often co-authors pieces with Dahlia Lithwick, put out a tweet 50 minutes ago, and he did a screenshot of the Bloomberg Law article. And I'm going to read this because we know so little about this decision. And I love how Daniel constantly corrects me. We don't know if this is the decision. This is a leaked opinion. He's more accurate.
It's a rough draft. Like I was telling you.
Wait, let me just say what I'm going to say. Hold on. Let me just read it. And then so it says, I'm reading to you from the Bloomberg piece. The copy indicates that the court is voting 6-3 to lift a stay it previously placed on a federal district court with conservative Justice Clarence Thomas, Samuel Alito, and Neil Gorsuch dissenting. Okay, so let's see. So there were 3 dissents. Now here's what Ketanji Brown Jackson wrote. It says, KBJ wrote separately to say that she wouldn't have dismissed the case, according to the copy that was briefly online. And this is the quote. Today's decision is not a victory for pregnant patients in Idaho. It is a delay. While this court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position as their doctors are kept in the dark about what the law requires. That's exactly what you're saying, Daniel. We don't know.
Well, yeah, I respect Justice Brown. She's from Miami. I was born in Miami, so she's a Florida, and she was a judge. Yeah, I mean, I think that appears to be the case. That what she said. That's why these cases, like I think I said on one of our others, the Dobbs decision is so monumental in so many respects. And I don't think it contemplated this situation clearly. And this is just the first one. And so basically now just leaving it in limbo. I would say it's limbo. I think what she said, it's uncertainty, it's limbo. It's and any uncertainty when you deal with this important of an issue, a woman's right to make decisions about which are going to affect her life. And there's nothing, the life of a mother and during in this situation. And now we have the Biden administration appears to have tried to, address it with some maybe clarity. But yeah, I think it's a punt, and it basically who does it help? I don't think it helps anybody. But I think the Dobbs decision has not helped anybody either. I don't, it's created so much uncertainty, and it's not, it's just, when you have a law a decision that's in place like Roe v. Wade for so long,
50 years, yeah,
you have so many things that follow, not just the, general popular understanding and acceptance of what's allowed. I would beg to guess if I walked down the street here in Florida and said, "Did you know there's a 6-week abortion ban in Florida?" I would say, I don't know how many people would even know that.
So before we pivot to our next topic, I want to emphasize what Daniel has said again, which is we are still learning about this. This is breaking news. We did not expect this decision. After the two opinions were released at 10 a.m., that's what we thought it was going to be. And now we have this weird leak. We don't know if it's a final decision or if it could change. And I want, Daniel and I before the show were talking about this. How weird is it that this decision got released and it was yet another leak of an abortion related decision?
Yeah, I mean, I think, in terms of, I imagine that there's a pretty, uh, thorough and intricate protocol that the Supreme goes through before they put something on their website. At least I hope, I anticipate. I mean, they have a lot of employees. I mean, to go from an opinion that gets on the website and then they take it off. I mean, that just adds to the confusion. So, I mean, who is in charge up there at the Supreme Court? Who's in charge of these decisions?
Roberts. He's ultimately the decider.
I don't think Roberts is. I can't imagine Justice Roberts is. I don't know. Maybe
now he is. Now he knows.
I know but is he deciding when something gets put on the website?
No, what I'm saying is he's probably been informed that it leaked. And now he has a decision, right? You know the expression, you play your ball where you find it in golf? This is where it is. The hand he has been dealt is that this leaked. And I guess they've made some sort of announcement acknowledging the court has that it's leaked and it will be released in due course or something, which is, who knows what that means.
I mean, that just, I mean, I've been trial court. I've never seen. I mean, when I get a trial court order, I mean, I've never gotten an order that's, oh, well, that was a mistake. Well, I want to bring it back. I mean, now we have two in abortion cases in the past couple years from the highest court in the land. I don't know if it's a test balloon. I mean, it's like a Trump thing where you throw something out and let's see how people react. I mean, but this is just I don't know what happened. I just know that it's sloppy. And it's definitely, I'm hopefully it's not intentional. I'd be, intentional.
Well, intentional or not, Daniel, I'm thinking about the time.
And it really, like I said, recently I said, I think if you would have polled the American public 20, 30 years ago in terms of what they would think of the Supreme Court, what percentage of favorable ratings would they get? I think it would be pretty high. But now with these decisions, with these actions by getting, going on trips and then filing a new disclosure about, oh, well, I didn't mention that I got this from this guy, or putting a flag upside down. I mean, the Supreme Court is supposed to be like sacrosanct. When everyone grows up, they're Thurgood Marshall, Just Harlan, all Frankfurt, all these folks that have just lived on in time. Now we have this. Well, we're going to slip. I mean, it's just sloppy, and it adds to the people's
disdain for the court. Yeah, I mean, I think it has fallen.
Lack of trust,
Yeah, I mean, I think what you talk about the stature of the court, what concerns me about, what was going on here, about, the decision to punt here. What makes me nervous, something Kyle just reminded me in the chat, was remember that Donald Trump, if he is in office or Republicans have control of Congress, they want to pass a federal law that would ban abortion nationwide, right? And it would preempt the states. And so this kind of case about the interrelationship between federal and state law when it comes to abortion, like normally we think about, that federal law is, supreme, that federal law, trumps state law. But that's not always the case. We've had situations in court cases where, like when it comes to, things like credit card interest rates. And there's just different things that Congress can do. I mean, to give states certain rights or to preempt those, the preemption doctrine. And I'm just nervous about that. Are you?
I did see, yes, I think that, yes, certainly if we had a Trump administration, they would not be bringing this action. So I guess now, yeah, I mean, that's why elections matter, because, you have President Biden who they understand that there's federal implications, and they took I think a novel and good approach to say, hey, well, there's a federal law that says you can't do this. Well, federal law does normally preempt, as you know, but there's certain doctrines of abstention and where it doesn't apply. And yeah, certainly, maybe there's a debate tomorrow. I don't know if that has anything to do with it, but I mean, abortion is going to be, I know, we have in Florida here, we have on the ballot, we're having an amendment to address abortion rights, marijuana right. I mean, so you've seen other conservative states where, Kansas, where there's states that are red, that overwhelming majority of the public does not agree with these very restrictive measure. So,
So I really would love to.
I think
Another
maybe,
day we can get into a topic about preemption, but I want to stay on these breaking Supreme Court
right.
cases. And you mentioned, a good segue to the next case is you mentioned, the corruption at the court with some of the justices like Alito and Thomas, getting their benefactors to give them free plane rides and all that type of thing. So it shouldn't be entirely shocking that today a 6-3 decision came down weakening the
Yeah.
federal bribery laws. And, as soon as I saw this decision, I popped out my white collar crime casebook. But this is, I'm sure you saw this one, Daniel, from this morning. This involves this federal statute known as the Federal Program Bribery Statute. So it's a federal statute that allows federal prosecutors to go after corrupt state or local officials under this statute, but only if this particular one, only if these if the person who is the defendant has been a recipient of federal funds. It's like a follow the money. You take federal money, then if you are also getting, bribes or gratuities, you could be prosecuted. And the guy involved in this case was the mayor, a guy named James Schneider, who was the mayor of a city in Indiana. And he was convicted of this federal funds bribery in violation of this statute I mentioned, because after he awarded certain contracts to these garbage removal companies, after he gave them the contracts, he went to them and said, hey, I gave you these contracts, now pony up some money. And he got $13,000 from them. And his conviction was overturned because the Supreme Court in this case decided made this decision that it was okay to do that. What are your thoughts on this?
I mean, yeah, and I guess it brings in this familiar term. They're saying, I guess they argued that without a quid pro quo agreement, that it wouldn't that this statute would apply. But I'm
Well,
in
let
a
me just, yeah. Well, what's weird though is 18 USC 201. There's a different federal statute that goes only after federal officials,
right. Okay.
and it's the anti-gratuity statute. And they say with that one, you still need a quid pro quo. You need that someone gave you a tip for a reason, but tipping someone for doing something, even if it wasn't pre-negotiated, if it's still considered unlawful. Here, like the justices who wrote the majority opinion was like, nope, this statute doesn't explicitly prohibit, asked for kickbacks. So, oh, well, it's okay.
I'm at a loss, I guess, as to why this is. I mean, I think that these types of decisions, and this was a state mayor that they decided under federal law would violate the law. I mean, we're talking about $13,000. I mean, whatever you want to call it. I mean, but for this, I just think that this is something that I'm not sure why. As the Supreme Court has carte blanche about what kind of cases they can accept, and they have a huge amount of discretion. So I don't know
why they took the case.
Yeah, I mean, I don't know.
I think you know why. Why do you think they took the case? I think you can give a few guesses.
I don't. I mean, there has been some recent, stories about payments to, or not payments, but gifts and to Supreme Court members who were, later they were undisclosed. Now they were corrected. I mean, I don't know what. I mean, I hope that's not.
Well, I mean, I think it's partially that. I mean, because what they're kind of saying is, if the statute doesn't explicitly forbid something, even if it looks questionable or looks quote unquote corrupt, if it's not literally in violation of a specific statute, if you cannot find, like you're saying, quid pro quo bribery, then, or even quid pro quo gratuity for them, it's not a problem. In this case, though, they said this was about leaving it to the states. And that concerns, right? This is the theme of the court, right?
That's another thing. I think, full disclosure here, I'm a Democrat, but I was a Republican for a while. And that was my understanding. A big principle was to be local control, local prosecutors, defer to states. I mean, that doesn't, it seems to be very selective now, and so-called Republicans, whatever you want to call them. But I do think that I'm wondering why this kind of got to the top of the list before the immunity case. I mean, there seems to be a lot more. There seems to be a lot more important cases than a $13,000, whatever you want to call it, of a mayor in Indiana. I mean, like, if there's a, I just don't. I was growing up just before I became a lawyer. The Supreme Court decisions it was like you get the pick of the pick. You have the best law clerks. You have all this staff. You have usually because they have the pick of the litter, what they can hear. There usually is some reason why.
Let me put my professorial hat on, and it's not just this is it's very much in line with recent Supreme Court decisions around corruption, where the Supreme Court has overturned convictions, like the Bridgegate case, where they're saying, remember the Bridgegate case where they were to get back at the mayor of Fort Lee, these folks put up traffic cones to help Chris Christie, who was the governor of New Jersey.
Right.
And that was overturned because they decided that there was no property interest. It was a regulatory, it wasn't considered, what do they call honest services fraud, because that statute required a property interest, and this was regulatory interest. And if states want to be vindictive or misuse their regulatory power, that's a state issue, not a federal law issue. And I think they're kind of doing the same thing here. Yeah, this guy only got $13,000 in bribes, and so what? I think they really want to end the federal enforcement of against local and state officials. And what bothers me the most is, if someone is, in this case it was a mayor, right? But who's going to prosecute if the governor is corrupt, you're not going to have the criminal justice machine go after him. And that's sort of the reason why you want federal laws. And one last thing I'll say is this doesn't get rid of all federal laws that go after public officials. There's this other statute called, 18 U.S.C. 1951 that deals with extortion and shakedowns under color of official right. But I bet you that will not be able to be used for gratuities. I bet that will only be able to use for sort of local bribery as well. The court is trying to defederalize crime, I think.
Well, I think that, in this case, and I would be interested to see how, he got convicted. He got a 21-month prison sentence. I would be. How often does the Supreme Court intervene in a criminal sentence in a white collar public? I mean, that doesn't. I mean, they are here for for a reason. I think, and like you said, there's been other recent decisions where they've also tried to pull back on public. Basically, because when you have local state officials, to get a state attorney to go after a county commissioner or a local state official, it's not very likely. So that's where the federal. But if you have a U.S. attorney who's appointed, has there's not state attorneys in Florida are elected. They're oftentimes like right next to the office of the county commissioner or whomever, and in small town. I mean, that and not that they don't look into it, but certainly. That's what has been in historically when local state county prosecutors don't want to do something to a local official. I mean, they know these people. I mean,
can I read from the case? This is really fun. And then maybe we can have one, before we close, we can talk about Menendez and then give some announcements about nerds generally. So this is this great quote. The question in this case is whether this law also makes it a crime for state and local officials to accept gratuities. This is what Kavanaugh wrote, right? For example, gift cards, lunches, plaques, books, framed photos, or the like that may be given as a token of appreciation after the official act. Where are the yacht vacations and the fancy wine and the...
I mean, yeah, it's
this is like the low end bribery.
I just think that being a public official, people should go into that with good intentions, and to have you have a federal prosecutor, you have a jury, convicts him, 21-month sentence, under a law that he clearly, for whatever reason, maybe there was a state violation, but the state prosecutor didn't want to do something for whatever reason. But then for the Supreme Court to come in and overturn this case for, apparently for purchase of garbage trucks. I mean, I don't know. I mean, this is I don't know what the politics is in Portage, Indiana. Indiana is probably a pretty conservative. I know it's a pretty conservative state. I'm sure. I don't know which county is, but probably the prosecutor in that area is pretty. Most U.S. attorneys are pretty conservative anyway. I mean, they're not. So I just think that this is, like you said, it appears there's been a pattern recently of trying to, I guess it would be interfere or stop federal prosecutors from doing their job against government officials. And
Yep.
that, I don't know why that's a priority for the highest court in the land.
Good question. So I just want to give a quick update and get your reflections, because I know that you at one time clerked for a federal judge and dealt with federal white collar crime. So if you can believe it, Senator Bob Menendez is still on trial. I think the trial began something like May 13th. And, obviously there are weekends and days off, but I think we're like on day 34 of the trial. And he was not getting things like gift cards or frame photos, right? We're talking about bars of gold, car payments for his wife. And this isn't even his first case. Now, he is a U.S. Senator from New Jersey, so we don't have to worry about any of these weird state law or state official things. But what is your thought on the Menendez case?
I mean, yeah, it does seem to be going on a very long time. It seems that, what happens a lot of times when you have people who are in power or have powerful positions, they're able to do that, and they're able to delay things, prolong things. He's obviously has those. Whether he's had the ability to do that, and that's most people who are charged with white collar crimes who are do not have those opportunities.
Or a second chance, right? This is the second time.
Yeah, when I clerked in the Federal District in Miami, and those cases, they moved them fast. I mean, there was like a rocket docket, federal.
What do you mean? How fast?
Well, they were trying to get things through in a year.
Uh-huh.
And so from the time that the indictment till trial, I mean, there's so many cases in the Southern District that, I mean, just to move it, and that there wasn't, because, certainly a delay, if assuming he's guilty, helps him, former Senator Menendez. But yeah, I don't think I think it shows kind of the different types of justice there in this country for, he's a Democrat, whatever, he's a U.S. Senator. I mean, for Donald Trump, he had he could apparently, I don't know anyone that's violated so many gag orders and it wasn't held in contempt or put in jail.
Exactly.
It's just this level of justice for, if you're a former elected official that seems to be different. There's a different form of judicial system that you get, whether you're a Democrat or Republican. I mean, Menendez is a Democrat, but he's a crook. I mean, it's like, I don't think there's any dispute that he's,
well, guilty. I mean, here's, maybe the good news here is that Donald Trump, he is a federal official, but it's the reverse. He's been tried and convicted on 34 felony counts in state court. So sometimes the reverse is also the case. Let's wrap things up with a few notes about Nerd Avengers. We usually meet live every Tuesday, Thursday at noon, and Sundays at 6 p.m. But tomorrow, because it's Debate Thursday, instead of going live at noon, we will be live at 8:45, just 15 minutes before showtime, and we will be your favorite nerds there together, talking about and watching with you the debate. I think we're going to be running the C-SPAN feed, and we will be watching. We will interrupt at appropriate times, not too much, so you can still hear the event. And I literally today bought a giant pack of Twizzlers. I am ready. Daniel, what kind of snack do you usually like to go to, or beverage, when you are at these kinds of events?
You mean watching the debate?
Yes.
The last debate between Biden and Trump, I think I have young kids, we have teenagers, and I try to keep them in the room as long as possible, because it's important, I believe, for, younger generations to participate.
Sure.
And so this one, I mean, Trump he's going to make it a show. Whatever he's going to try, and it's. I think President Biden.
Daniel, you're not answering my question. I want to know what snack you're having.
I do. Well, now I'm on a diet, so I used to.
You look fabulous, but okay. So what healthy snack? Rice cakes?
Frozen grapes are my new.
Ooh,
they actually taste like candy, but they're good for you. So,
okay,
I
like
used to
that.
have red Twizzlers. I'd eat a whole bag in like 30 seconds, but now I've got I have a trainer that I go to, and he asks me what I eat every night. So. And he like puts a lie detector on me, so I would say frozen grapes and water and that's it. It's pretty boring in my house in terms of.
I know what I like this idea of frozen grapes. It's probably healthier than other options. So I'm gonna throw some grapes in the freezer.
Oh yeah, you'll love it. If you can't stop eating them. But you're supposed to eat early in the day. But no,
I know you're supposed to not eat until after 8 p.m. any day. I know. But live a little. That's what I say.
This debate is, it's. I think it's going to be enlightening. I think President Biden is one of the few people I think who can really go toe to toe. I mean, because Trump, if you remember in 2016, there was 7 or 8 people on the stage within the Republican primary, like Jeb Bush, Marco Rubio, and he just kind of, went all over them. But yeah, I mean, I don't know. What are you going to have? You're having Twizzlers and what else?
Well, I think I'm probably going to have, my favorite beverage, some sort of Coke Zero, maybe some Twizzlers. I have those. Hey, so listen, we have someone in the chat. Susan Thompson says she will be having Trader Joe's crunchy onion hummus dip and cheese and crackers. I love the crunchy onion hummus dip. Susan, I need to know, do you stir it all together or do you try to take like just a scoop of that center yummy hummus dip? Please tell us in the chat. And then someone named Daniel Newman. Hey, Daniel, his tomatoes finally are finally coming in. So he's going to be snacking on BLT sandwiches and potato salad. Please tell me, Daniel Newman, that you do not put any raisins in your potato salad. I don't know. Okay.
Maybe in honor of Trump, we should all eat McDonald's because that's all he eats, right?
No way. I would never.
No, yeah. I mean, the funniest.
I'm not going to. The only thing I'm going to supersize is my contempt for Donald Trump. So I think we should call the show.
He said he only ordered McDonald's because he was afraid everyone else was going to poison him.
Yeah, well,
so
it's a slow death.
It's going to be interesting. I think it's going to be an important night, and I think this. We're getting election season. I mean, it's starting to get there. After.
I think we got to wrap, Daniel. I could talk to you all day, but I see that we are like 8 minutes over. It's supposed to be a half-hour show. Okay. Folks, forgive us, but we're so glad you stayed with us. Thanks so much for joining us.
And we'll be here next Wednesday at the same time, and we'll see what kind of surprise opinions show up on the website briefly. Just report then and come get removed.
That will be fun. And if they're all done, I'm sure we're going to have some other exciting breaking news to talk to you guys about.
All right. Well, thank you.